You're nothing but trailer trash pretending to matter. Judge William Harper didn't just say it. He screamed it, stood up, slammed both hands on the bench so hard the gavel jumped. Your mother's pathetic. You're worse. Get out of my courtroom. He grabbed Mitchell's papers, 3 years of his mom's work, and ripped them apart. Threw the pieces at the 9-year-old's face. Bailiff, drag them out! Everyone laughed. Mitchell's mom was on her knees, sobbing, picking up torn papers. The bailiff's hand clamped Mitchell's shoulder. Then Mitchell spoke, ice cold. You just broke the law, Your Honor. Silence. Henderson v. Langley, 2018. You can't dismiss without reviewing evidence. I have 47 more cases memorized. Judge Harper's face drained white. Subscribe now. What this kid does next doesn't just shock the courtroom, it changes everything. But before I tell you what happened in that courtroom, you need to understand how a 9-year-old learned to fight a system designed to crush people like his mom. This story starts 3 years earlier. Mitchell Douglas was 6 when his father walked out. Didn't just leave. Cleaned out their bank account. Left $23,000 in debt. Mitchell stopped talking for 2 months. Rachel Douglas, Mitchell's mom, worked night shifts as a nurse at County General, the kind where every beep could mean someone's dying. She'd come home at 6 a.m., sleep 3 hours, then care for her traumatized son. It wasn't enough. So she added weekend retail shifts, 8 hours on concrete floors, smiling at customers who treated her invisible, swollen ankles, paychecks that barely covered rent. 2 jobs, no family, no support, just her and Mitchell against the world. They were surviving, until the eviction notice. Stephen Moore, their landlord, claimed Rachel damaged the apartment. Water damage, broken cabinets, stained carpets, $3,000, 30 days to pay or get out. Rachel knew it was a lie. She documented everything at move-in, time-stamped photos. The water damage already existed. She'd texted Moore day 1. Loose cabinets were in the inspection report. Carpet stains, too. She had proof. But Moore had a lawyer. Rachel called every legal aid organization. 6-month wait list. 8-month wait list. Not taking new cases. Try representing yourself. So she did. Color-coded folders, printed documents, lunch breaks at the library reading tenant rights, nights until 3 a.m. making notes. She tried so hard, but she didn't know about precedent, case law, the legal framework judges actually care about. Moore's attorney knew she didn't know. That's why they rushed to court. They assumed Rachel would crumble, settle, disappear. They didn't know about Mitchell. While Rachel exhausted herself, Mitchell studied. Not schoolwork, law. It started the night his father left. Mitchell heard his mom crying, heard her on the phone with a lawyer demanding $5,000 up front. Mitchell understood something at 6. His mom needed protection. Nobody else would provide it. So he read her papers. Late nights after Rachel collapsed in her scrubs, Mitchell crept to the living room, read her documents, eviction notices, tenant pamphlets, lease copies, every word. Didn't understand at first. Kept reading anyway. Then the library. The public library on 5th Street became Mitchell's sanctuary. Weekend drop-offs while Rachel worked. Other kids went to story time. Mitchell went to law books. Introduction to Civil Procedure. Tenant rights, a comprehensive guide. Books law students struggled with. Mitchell read them all. George Patterson noticed. The librarian, 68, retired paralegal, watched this tiny kid reading lawyer books. One Saturday, Patterson sat down. Heavy reading. How old are you? 7. That's about tenant rights, boring stuff. It's for my mom. Patterson paused at Mitchell's tone. She in trouble? Landlord's evicting us. She can't afford lawyers. Patterson stayed quiet. Then, what if I help you find the right books? For 2 years, George Patterson guided Mitchell, pulled specific volumes, explained terminology, showed him case citations, precedent, binding versus persuasive authority, never asked why, just helped. Mitchell had photographic memory, didn't know that was unusual, thought everyone remembered page numbers after one reading. He memorized everything. By 9, Mitchell had read 73 law books, memorized 52 tenant law cases, could recite procedural rules perfectly. Rachel had no idea. The morning of the hearing, Rachel's hands shook. Coffee-stained pages, 3 highlighter colors, sticky notes, inspection report. Photos first. Stay calm. Mitchell watched. His backpack held the library textbook. Baby, be brave today. Sit quiet. Don't say anything. Okay, Mom. But he thought, I've read everything. I know what you're missing. On the bus, Rachel practiced silently, lips moving. Mitchell wanted to help. Mom, I know the cases, I know the law, but she'd never allow it. Too young, not his burden. He stayed quiet. The courthouse loomed, stone, authority, intimidation. Inside, fluorescent lights hummed. Lawyers in expensive suits strode past, everything designed to make you small. Rachel found their courtroom, hard bench outside, waiting. She squeezed his hand. Whatever happens, we're okay, you and me. I know, Mom. He lied. He'd read the statistics. 90% of pro se litigants lose, especially against landlords with attorneys, especially in Judge William Harper's courtroom. Harper had 20 years on the bench. Efficient courtroom. One reputation. He destroyed unprepared, self-represented litigants. He dismissed cases for less. The bailiff opened the door. Douglas versus Moore. Rachel stood, smoothed her thrift store dress, $12, the nicest she owned. Mitchell followed, backpack heavy with everything she needed. Neither knew what would happen, that Mitchell would stand, that he'd face a judge who'd intimidated people for 20 years, that he'd cite law the opposing attorney didn't know. But first, you need to see what Judge Harper did to Rachel. What happened next wasn't just dismissive. It was vicious. The courtroom felt like a tomb. High ceilings that swallowed sound, wood paneling dark with age, rows of empty gallery seats, and at the front, elevated like a throne, Judge William Harper's bench. Harper sat reviewing papers, 62 years old, silver hair, reading glasses perched on his nose, the kind of man who'd spent 2 decades wielding power over people who couldn't fight back. Case number 2024 CV 1856, the clerk announced. Douglas versus Moore. Rachel approached the defendant's table, hands trembling, folder clutched to her chest like armor. Across the aisle, Stephen Moore sat with his attorney, a man in a $2,000 suit, Rolex glinting, leather briefcase, the confidence of someone who'd never lost to a pro se litigant, never would. Judge Harper didn't look up. Miss Douglas, I see you're unrepresented, correct? Yes, Your Honor. Rachel's voice cracked slightly. Proceed. Rachel opened her folder. Paper shifted. One sheet slipped, fluttered to the floor. She bent quickly, face flushing. Your Honor, I'm here because Mr. Moore has made false damage claims. I have evidence, photographs from move-in day, repair receipts, text messages. Miss Douglas, Harper's voice cut like a blade. Do you have case law supporting your position? Rachel froze. Your Honor, I have documentation showing... I asked about case law, legal precedent. Do you have specific cases establishing your argument? Rachel's hands shuffled frantically through papers. She'd printed articles, tenant advocacy guidelines, but actual cases, names and years and jurisdictions? I have information about tenant rights, Your Honor. The law says... The law says? Harper finally looked up. His expression was contempt, pure, undiluted contempt. Miss Douglas, this is a courtroom, not a community college classroom. I need legal arguments, precedent, not something you Googled last night. Someone in the gallery snickered. Mitchell's hands gripped his seat edge, hard. Your Honor, I've been preparing for weeks. Clearly not well enough. Harper's voice was ice. Miss Douglas, I've seen high school mock trial teams more prepared than you. This is embarrassing. Rachel's eyes filled with tears. She blinked furiously, trying to hold them back. The landlord's attorney stood smoothly. Your Honor, if I may, it's abundantly clear the defendant is unprepared for these proceedings. She has no legal training, no understanding of procedure. She's wasting this court's valuable time. He paused for effect. I move to dismiss all counterclaims. Miss Douglas has presented no legal basis for her defense. Perhaps she should revisit this matter when she can retain proper counsel. He smiled. Though given her financial situation, that seems unlikely. The gallery actually laughed at that. Rachel's hands shook so badly papers fell from her folder. She dropped to her knees, scrambling to gather them, tears streaming now, no longer trying to hide it. Judge Harper sighed, long, theatrical, the sigh of a man dealing with incompetence. Miss Douglas, get up. You're making a spectacle. Rachel stood, mascara running, hands full of crumpled papers. Your Honor, please. Unless you can cite actual precedent in the next 10 seconds, I'm granting the motion to dismiss. I have the documentation right here. Precedent, Miss Douglas, case law, legal authority. Harper leaned forward. Do you even understand what I'm asking for? Silence. The attorney smirked. Moore leaned back in his chair, arms crossed. Victory. That's what I thought. Harper picked up his gavel. Motion to dismiss granted. Miss Douglas, you have... Your Honor. The voice was small, clear, came from the gallery. Everyone turned. Mitchell Douglas stood, 9 years old, barely 4 feet tall, worn backpack on his shoulders. Your Honor, may I approach? The courtroom went dead silent. Harper stared, blinked, like he'd misheard. Excuse me? Mitchell stepped into the aisle, started walking toward the front. Small footsteps on polished floor. I said, may I approach the bench, Your Honor? Rachel's face went white. Mitchell, no, baby, sit down. But Mitchell kept walking. Reached the defendant's table, stood beside his mother, looked up at Judge Harper. The judge's face was turning red. Young man, this is not a playground. Sit down. Mitchell didn't move. His voice stayed calm, respectful, but firm. Your Honor, I'd like to assist in my mother's representation. The courtroom erupted in whispers. Someone actually laughed out loud. Harper's eyes narrowed. You want to assist? You're a child. Yes, Your Honor, I'm 9, but I'm familiar with the case details, and I believe my mother's position has substantial legal merit. The attorney scoffed. Your Honor, this is absurd. Let him speak. Harper's voice was dangerous now, not amused, angry. I want to hear what this child thinks he knows about the law. He leaned forward, stared down at Mitchell. Go ahead, son. Enlighten us. It was a trap, an invitation to humiliate himself, but Mitchell had been preparing for this moment for 3 years, and Judge William Harper was about to learn something he'd never forget. Judge Harper didn't just lean back. He laughed. Not a chuckle. A full, mocking laugh that echoed through the courtroom like he'd just heard the funniest joke of his career. You want to assist? He looked at the clerk, at the bailiff. Did everyone hear that? This child wants to practice law. The courtroom erupted. Laughter rippled through the gallery. The landlord slapped his knee. The attorney grinned like Christmas came early. Harper pointed at Mitchell. Son, this isn't a school play. This isn't career day. This is the real world, where actual lawyers with actual degrees handle actual legal matters. Your Honor, I understand. You understand nothing. Harper's voice turned sharp. You're 9 years old. You should be home playing video games, not wasting this court's time. Mitchell stood perfectly still. Your Honor, with respect... With respect? Harper actually stood up, towering over the bench. You want to show respect? Sit down. Stop embarrassing your mother. She's already made enough of a fool of herself. Rachel grabbed Mitchell's arm. Baby, please, just sit down, please. Mitchell gently pulled away. His eyes never left the judge. Your Honor, I've reviewed the relevant case law. Case law. Harper said it slowly, mockingly. You've reviewed case law. At 9 years old. He looked at the attorney. Counselor, are you hearing this? The attorney stood, barely suppressing laughter. Your Honor, this is insulting. The boy has no legal training, no understanding of procedure. He probably saw something on television. I've read 73 books on civil procedure and tenant law, Mitchell said quietly. Silence for a beat. Then the courtroom exploded in laughter, louder this time. 73 books, someone shouted. Sure, kid. Harper shook his head, smiling. Son, I've been practicing law longer than your mother's been alive. 20 years on this bench, and you're telling me you've read 73 books? Yes, Your Honor. Where, the library? Yes, Your Honor, the public library on 5th Street. The public library? Harper glanced at his clerk. We have a 9-year-old lawyer trained at the public library. Back to Mitchell. Did you pass the bar exam in crayon? The gallery roared. Mitchell's face stayed calm. His hands, hidden at his sides, were clenched into fists. Rachel was crying. Full sobs now. Your Honor, please, he's just a child. Oh, I think he understands perfectly. Harper's voice dripped venom. He understands his mother is losing, so he's creating a distraction, a sympathy play. That's not... Mitchell started. I'm not finished. Harper's hand slammed the bench. The bang echoed. You want to play lawyer? Fine. Let's see what you've got. Tell me, since you've read 73 books, what case law supports your mother's defense? The courtroom went quiet, waiting. The attorney leaned forward. This was going to be good. Mitchell took a breath. Your Honor, I'd like to cite... Wait. Harper held up a hand, smiling. Before you embarrass yourself, let me guess. You're going to mention tenant rights, security deposits. Am I close? Your Honor. Because here's the thing, son. Harper's voice went soft, condescending. Tenant rights are general principles. What I need is specific case precedent, cases with names, years, jurisdictions, holdings. He paused. I'm going to give you one chance, not because I think you can do it, but because I want you to learn a lesson. When you don't know what you're doing, stay quiet. The attorney laughed. Your Honor, this is already a waste. Let him try. Harper's eyes glinted. I want to watch. Mitchell met his gaze. Ramirez v. Coastal Properties. Harper blinked. 2019, State Court of Appeals. The case established that in damage disputes, the burden of proof for pre-existing conditions rests with the landlord when the tenant provides time-stamped move-in documentation. Silence, not laughter. Actual silence. The attorney's smile faded. He reached for his laptop. Harper recovered quickly. That's one case. Congratulations. You memorized one name. Probably heard your mother mention it. I didn't. Rachel's voice was small. I don't know that case. Then he saw it online. Harper waved dismissively. Anyone can Google a case name. That doesn't mean he understands it. Mitchell continued like Harper hadn't spoken. The case specifically addressed landlords making broad damage claims without documentation. The court held that photographs taken within 72 hours of occupancy create a rebuttable presumption. The attorney was typing frantically. My mother took photographs on move-in day, Mitchell said. Time-stamped, showing water damage, loose cabinets, and carpet stains. Mr. Moore has provided no documentation proving these worsened. Harper's jaw tightened. One case doesn't make precedent. Henderson v. Langley Management, 2018. State Superior Court. Clear, confident. That case clarified that landlords must provide itemized evidence beyond normal wear and tear. The court rejected broad claims of general damage without receipts, estimates, or contractor bills. Mr. Moore's complaint uses the exact language Henderson rejected. The attorney found the case on his screen. His face went pale. Someone in the gallery whispered, "These are real cases." Harper's face turned red. How did you— Johnson v. Residential Holdings, 2020. Mitchell's voice was steady. State Supreme Court. That case established that time-stamped photographic evidence shifts the burden to the landlord. The landlord must prove through dated documentation that conditions deteriorated. Mitchell looked at Moore's attorney. Your client has none. No dated photographs, no inspection reports, no repair bills, nothing. The attorney stammered. Your Honor, this is irregular. Martinez v. Property Solutions, 2019. Mitchell kept going. State Court of Appeals, Volume 384, page 921. The holding is on page 938, footnote 12. Landlords who fail to document pre-move-out inspections within statutory timelines forfeit the right to claim damages. Harper stared, because Mitchell had just cited a page number, a footnote, from memory. Stevens v. Rental Properties, Inc., 2021, Mitchell continued. When landlords fail to provide itemized documentation during discovery, courts may impose sanctions including dismissal. The attorney was sweating. Your Honor, Wilson v. Greenfield Apartments, 2019, temporal documentation requirements. Cooper v. Westside Management, 2020, standards for photographic evidence. Franklin v. Residential Holdings, 2018, defined normal wear and tear versus compensable damage. Mitchell's voice never wavered. Each case clear, each citation precise. Paulson v. Metro Housing, 2019, evidentiary standards. Miller v. Property Group, LLC, 2021. Notice requirements. Landlords must provide written notice within 14 days. Mr. Moore sent his notice 3 weeks late. Dead silence now. No laughter, no whispers, just stunned silence. Mitchell finally paused, looked up at Harper. Your Honor, I can cite 43 more cases. Each one supports my mother. Each one shows Mr. Moore's claims fail basic legal standards. Harper's face had gone from red to white. The attorney was frozen. Every case Mitchell cited, real, accurate, applicable. A 9-year-old had just delivered a legal argument better than most licensed attorneys. Harper opened his mouth, closed it, opened it again. How? His voice was barely a whisper. How do you know all this? Mitchell's answer was simple, devastating. I learned it from my mom, Your Honor, because nobody else would help her. The gallery was silent. The attorney looked sick. Moore slumped in his chair. Rachel stared at her son like seeing him for the first time. Judge William Harper sat back down slowly. He'd just realized something terrifying. This wasn't a spectacle. This 9-year-old knew the law better than anyone in the room, and Harper had spent 10 minutes mocking him. "Approach the bench," Harper said quietly. "Both counsel and Mitchell." Mitchell walked forward, small footsteps that somehow sounded louder than anything else. Everyone waited, because what happened next would determine everything. At the bench, Judge Harper spoke low, just loud enough for Mitchell and the attorney to hear. "Mitchell, who taught you this?" "I taught myself, Your Honor. Mr. Patterson showed me which books to read, but I did the studying." Harper studied him. "Tell me about burden of proof in damage cases." "The initial burden rests with the plaintiff, Mr. Moore, to establish damage occurred during tenancy. Martinez v. Property Solutions outlines this." "What page was Martinez on?" "Volume 384, page 921. The holding is page 938, footnote 12. The attorney's pen dropped, clattered. Harper pulled out his laptop, typed, scrolled, looked up. Astonishment. "That's correct, word for word. My mother kept the book on her nightstand. I read it while she slept." Harper sat back. "Another case, discovery obligations. Stevens v. Rental Properties 2021. When landlords fail to provide itemized documentation during discovery, courts may impose sanctions, including dismissal. The case addressed landlords claiming damage without repair bills or invoices." The attorney interrupted. "Your Honor." Harper silenced him. "Does Mr. Moore have itemized documentation?" "We have photographs." "Taken when?" Mitchell asked. Everyone turned. "Photographs taken after the eviction notice carry less weight than move-in photos. Cooper v. Westside Management 2020. Harper smiled. "You've been busy. I wanted to help my mom. Return to your table. I want to hear more in open court." Mitchell walked back. Silence. Rachel pulled him close, trembling. "Baby, what?" "It's okay, Mom. I've got this." Harper addressed the courtroom, mockery gone. "Continue, Mitchell. I'm interested." Mitchell delivered. He started with foundation. Bedrock cases establishing modern tenant law, not just citing but explaining what they meant and why they mattered. Franklin v. Residential Holdings 2018 distinguished normal wear from compensable damage. Normal wear is deterioration from intended use without negligence. Carpet wear in traffic areas, minor wall scuffs, paint fading, landlords cannot charge tenants. Evidentiary standards next. Paulson v. Metro Housing 2019 requires landlords to distinguish subjective aesthetic complaints from actual damage affecting habitability or value. Personal distaste for carpet condition isn't compensable damage unless it exceeds normal depreciation. Procedural requirements. Miller v. Property Group 2021. Landlords must provide written notice of specific damage within 14 days of lease termination. Claims made weeks later don't satisfy the requirement. Delayed notice prejudices the tenant's disputability. The attorney objected. "Your Honor, overruled. Continue." Mitchell did. Security deposit law, inspection procedures, photographic evidence, each citation precise, each application clear. Garcia v. Sunset Apartments 2020. When documentation conflicts, courts consider credibility factors. Timestamp verification, financial incentive. Mr. Moore gains $3,000. My mother loses her deposit and faces eviction. Garcia held profit motive creates presumptive bias requiring stronger evidence. He addressed dissenting opinions. Justice Morrison's dissent in Bradley v. Northside Rentals 2019 argued for stricter documentation. Her position didn't prevail, but 3 subsequent cases adopted her reasoning, including Peterson v. Valley Management 2022 in our jurisdiction. Recent law favors tenants when landlords fail to maintain contemporaneous records. The court reporter struggled. Fingers flying, Mitchell pulled case after case. Recent, older, state courts, federal courts. He explained jurisdiction, distinguished cases reaching different conclusions. Simmons v. Bayside Properties might support Mr. Moore initially, but that tenant admitted causing damage, disputing only cost. Factually distinct. My mother isn't conceding damage. She asserts it never occurred or existed before move-in. That distinction matters under Henderson's framework. The gallery was transfixed. This wasn't recitation, this was analysis. Mitchell addressed specific claims. Water damage? Williams v. Greenfield Apartments 2019. Landlords must establish source and timing. Pre-existing plumbing issues create landlord liability. My mother documented bathroom damage on move-in day. Notified Mr. Moore via text immediately. That satisfies her burden. Broken cabinets? Anderson v. Midtown Properties 2021. Visual evidence doesn't establish causation without proof the tenant caused specific damage. The landlord couldn't demonstrate cabinets were intact at move-in. My mother's photos show they were already loose. Carpet stains? Collins v. Residential Services 2018. Normal use over multi-year tenancy creates expected wear landlords cannot charge. Carpets have useful life expectancy. Landlords must prorate depreciation. 3-year tenancy on 10-year carpet means 70% maximum only if damage exceeds normal wear. He explained burden shifting. Once tenants provide evidence of pre-existing conditions, burden shifts to landlords to prove worsening. Moore failed completely. The attorney's laptop sat forgotten. Mitchell cited faster than verification. When the attorney pulled up cases, Mitchell's descriptions were accurate. Every time. Harper asked about appellate standards. Mitchell explained clearly erroneous standard for factual findings versus de novo review for legal conclusions. Why this case involved primarily legal questions receiving de novo review. She asked remedies. Mitchell outlined them. Dismissal of damage claims, return of security deposit with interest, potential attorney fees, though we didn't hire an attorney. She asked about comparable cases. Mitchell provided 3 examples, explained outcomes, distinguished one against the tenant. That involved refusing pre-move-out inspection, creating adverse inference. My mother cooperated fully. Finally, Mitchell paused. Your Honor, the law is clear. Precedent is established. The burden is on Mr. Moore. He hasn't met it. My mother's case has substantial merit. 43 cases, cited from memory, applied with precision, explained with clarity. Harper sat motionless, the attorney silent, the bailiff's mouth open. Rachel squeezed Mitchell's hand. Her son, who'd spent 3 years preparing while she slept. The silence was absolute. Harper spoke. Counselor, your response? The attorney stood slowly, opened his mouth, closed it, looked at his client. Moore's face was pale. Your Honor, we need time to review these citations. You've had weeks to prepare, Harper said coldly. A 9-year-old prepared better than a licensed attorney. The words hung like a blade. Mitchell had destroyed the case. With knowledge, preparation, love, everyone knew what was coming. The attorney's confidence evaporated. Moore slumped. The gallery watched, stunned. Harper turned to Mitchell. Young man, I need to ask directly. Mitchell nodded. Yes, Your Honor. Did anyone help you prepare? Did your mother coach you? No, Your Honor. My mother didn't know I was studying. I did this alone because I wanted to protect her. Rachel's tears flowed. She'd had no idea. And you memorized all these from library books? Yes, Your Honor, Mr. Patterson helped me find books, but I read them myself, multiple times. I wanted to understand everything correctly. Harper shook her head slowly. Wonder, not disbelief. In 20 years on this bench, I have never witnessed anything like this. She looked at the attorney, then Moore, then Mitchell. We're taking a brief recess. 15 minutes. When we return, I expect both sides prepared for my ruling. She stood. Everyone rose. Court is in recess. The gavel came down, and everyone understood completely. The impossible had happened. A 9-year-old had outperformed a licensed attorney, had cited more law than most lawyers knew existed, had proven preparation could overcome every disadvantage. Mitchell stood beside his mother, holding her hand. She looked at him, tears streaming. Baby, how long have you been preparing? 3 years, Mom. Since Dad left, I heard you crying. I knew I had to help. Rachel pulled him into a fierce hug, sobbing. The gallery filed out slowly, talking in hushed voices. The attorney sat at his table, laptop open, frantically verifying. His hands shook. Every single one Mitchell cited was real, accurate, applicable, devastating. He was finished. He knew it. Moore stood, walked to his attorney, whispered urgently. The attorney shook his head, helpless. He knows the law better than I do. Mitchell had dismantled everything. With library books and photographic memory, the 15 minutes felt eternal. Rachel held Mitchell's shoulders, looked in his eyes. Why didn't you tell me? Because you would have said I was too young, that it wasn't my responsibility. But Mom, it was. You needed help. I could help, so I did. Fresh tears. I'm so proud of you. I know, Mom. The bailiff opened the door. Court is resuming. Everyone filed back. The energy had changed completely. Judge Harper returned, sat, surveyed the courtroom. Her expression was unreadable, but everyone felt it. Justice was about to be served. The attorney looked defeated. Moore looked sick. Rachel looked hopeful for the first time in months. And Mitchell stood calm, ready, because he'd done everything possible. He'd learned the law, memorized the cases, made the argument. Now it was in the judge's hands. Harper picked up her gavel. The courtroom held its breath. What happened next would determine everything. Their home, their future, their lives. One decision, one moment, one judge who'd just witnessed the impossible. Mitchell squeezed his mother's hand and waited. Judge Harper sat down. The courtroom held its breath. She looked at her notes, at the laptop, at the attorney, at Moore, at Mitchell. Silence. Heavy, suffocating. Nobody moved. Rachel's hand trembled in Mitchell's. The attorney shifted. Moore stared at the table. Harper's pen tapped. Once, twice, stopped. 30 seconds, 40. A full minute of silence. Mitchell stood calm. Finally, Harper spoke. In 20 years on this bench, I have seen thousands of cases. Thousands of attorneys, some brilliant, some who never should have passed the bar. She paused. But I have never witnessed anything as thorough, as precise, as accurate as what I just heard from a 9-year-old child. The words hung. Mr. Moore, you came claiming $3,000. You provided vague allegations, undated photographs, no estimates, no bills, no reports, no documentation proving damages occurred during Miss Douglas's tenancy. Moore's face went red. Your attorney called her unprepared, called her case without merit, but the only unprepared party here is you. She turned to the attorney. Counselor, I asked a simple question. Does your client have itemized documentation? You said photographs, but you couldn't tell me when they were taken. You couldn't provide dated reports. You couldn't offer a single piece of evidence meeting case law standards. The attorney opened his mouth. Case law that a 9-year-old cited better than you. He closed his mouth. Harper turned to Mitchell. Young man, you cited 43 cases from memory. Page numbers, footnotes, holdings. You explained frameworks, standards, requirements. You did what few attorneys could do. Mitchell nodded. Thank you, Your Honor. Don't thank me yet. Harper looked at the attorney. Counselor, your motion is denied. The attorney's shoulders slumped. Furthermore, based on the precedents cited, I find that Mr. Moore has failed to meet his burden of proof. Moore shot to his feet. Your Honor, sit down. Her voice cracked like a whip. Moore sat. You came with allegations, no proof. You attempted to intimidate an unrepresented tenant. You filed hoping she'd give up. That ends today. She typed something. The burden has shifted to you, based on Miss Douglas's time-stamped photographs, text documentation, and receipts. I find the alleged damages either did not occur or existed prior to her tenancy. Rachel gasped. Therefore, Mr. Moore's damage claims are dismissed. Miss Douglas's security deposit will be returned in full with interest within 14 days. The attorney stood. Your Honor, I'm not finished. He sat. I'm concerned about Rule 11 violations. Filing claims without investigation. Did you investigate before filing? Did you compare allegations to Miss Douglas's move-in documentation? Silence. We'll address sanctions later. This case is decided in favor of Miss Douglas. She turned to Rachel, expression warming. Miss Douglas, your son did something extraordinary. He reminded this court of something important. Justice isn't about power. It isn't about who can afford expensive attorneys. It's about preparation, truth, and caring enough to get it right. She looked at Mitchell. This 9-year-old spent 3 years teaching himself law to protect his mother. He didn't have money, he didn't have connections, he had a library card and determination. She looked at Rachel. You're raising someone exceptional. Rachel nodded through tears. Harper picked up her gavel. Motion denied, claims dismissed, deposit returned with interest. Moore pays costs. This court stands adjourned. Bang! For one heartbeat, nobody moved. Then the courtroom exploded. Applause erupted. Spontaneous, thunderous. People stood, clapping, cheering. The bailiff moved to stop them, but Harper held up her hand. Let them celebrate. Rachel grabbed Mitchell, crushing hugs, sobbing. You did it. We did it, Mom. The applause continued. The attorney gathered papers, face red, left. Moore stood frozen, defeated. Harper watched, smiled, then left. But before disappearing, she turned, looked at Mitchell, nodded once, respect, then gone. The courtroom quieted. People gathered belongings. An elderly man approached. "Most incredible thing I've ever witnessed." A woman followed. "Your son is extraordinary." More people. "Congratulations." The court reporter smiled. 32 years, never typed anything like that. The bailiff approached. "Kid, brilliant future ahead." Mitchell accepted praise quietly. This wasn't about glory, it was about his mom. Rachel pulled back, looked at his face. 3 years. You studied 3 years for me. "Of course, Mom, you're everything." Fresh tears. "I love you so much. I love you too." They stood holding each other. The impossible had happened. The underdog had won. Through preparation, knowledge, courage, Mitchell walked in as a 9-year-old kid. He walked out as something more. A reminder that justice was possible. Outside, word was spreading. "You won't believe what happened. A 9-year-old destroyed a lawyer. The story would spread, but right now none of that mattered. What mattered was Rachel and Mitchell together. Justice served." Rachel kissed his head. "Let's go home." Mitchell smiled. "Yeah, Mom." They walked toward the exit, past empty seats, past the table, past the bench. The bailiff held the door. "Be very proud." "I am." They stepped into the hallway. Everything had changed. Rachel had her deposit back. Her home was safe. For 3 years, her son had been working, quietly building knowledge to protect her. When the moment came, he'd been ready. They pushed through doors, stepped outside into sunshine. Fresh air felt like freedom. Rachel looked at Mitchell. "You know the best part? You're only 9. You've got your whole life ahead. If you can do this now, imagine later." Mitchell smiled. "I'm going to be a lawyer, a real one. Help people like you, people who need someone to fight." Rachel's eyes filled. "You're going to be amazing. I learned from you. You never gave up. You kept fighting when everyone said you'd lose." They stood on the steps, mother and son. Behind them, the building represented justice. Ahead, the city stretched out. Mitchell had proven something, that the system could work, that justice was possible, that knowledge was power, that love could overcome anything. "Come on, let's get that ice cream." Mitchell grinned. "Can we get 2 scoops?" "After today, you can have the whole shop." They walked down the steps, laughing, free. The battle was over. They'd won. Rachel squeezed his hand. "I'm so proud of you." "I know, Mom. When did you become so brave?" "The day I decided you deserved someone to fight for you." More tears. "I don't deserve you." "Yes, you do. You work 2 jobs. You never complain. You're the bravest person I know." They reached the sidewalk. Cars passed. People walked. Normal life. But for Rachel and Mitchell, nothing was normal anymore. Mitchell had faced down a judge. Cited law attorneys didn't know. Won a case everyone said was unwinnable. He'd done the impossible. For love. Rachel stopped, knelt down, looked Mitchell in the eyes. "Promise me something." "What?" "Promise you'll use this gift, this incredible mind. Promise you'll help people who can't help themselves." Mitchell didn't hesitate. "I promise. And promise you'll never forget where you came from. Never forget what it feels like to be powerless." "I won't, Mom. I promise." She hugged him, tight. "Okay, now let's get that ice cream before I cry all the water out." Mitchell laughed. First real laugh all day. They walked down the street, hand in hand. A mother and son who'd just beaten the system, who'd proven David could still beat Goliath. That preparation could overcome privilege. That love was the strongest force. The sun was setting, golden light painting the city. Rachel looked at Mitchell, at this extraordinary child. "I love you, baby. I love you too, Mom." And in that moment, everything was perfect. The struggle was over. The fear was gone. They were free, finally, completely free, and nothing would ever take that away again. The ice cream shop was 3 blocks from the courthouse. Mitchell chose chocolate chip. Rachel got vanilla. Rachel could finally breathe. "Are you okay?" Mitchell asked. She laughed. "You just saved our home." He shrugged. "Glad it's over." Rachel took his hand. "Do you understand what you did today?" "I helped you, Mom. You showed everyone that justice is possible. You taught me that. You never gave up. I was terrified every day. I know that's why I learned." Tears fell. You were 6 years old. 7 when I got serious. Mr. Patterson helped. We need to thank him. Rachel's phone buzzed. Jennifer Martinez, public defender, wants to talk. Mitchell smiled. She runs a program for kids. You want to do it? Yeah, Saturdays. Of course. Mitchell grinned. Another scoop? Yes. He ordered mint chocolate chip. Are you mad I didn't tell you? No, but sad you carried this alone. Learning was fun. Every case was like a puzzle. You gave up childhood. I protected the person I love most. She smiled through tears. They finished slowly. Outside, golden hour, they walked toward the bus stop. What happens now? Moore returns our deposit in 14 days. With us, our lives... Rachel knelt eye level. We keep living, without fear. He hugged her. I love you, Mom. I love you too. Can we go to the library? Tell Mr. Patterson? Of course. They headed to 5th Street, where this began 3 years ago, where a 6-year-old first opened a law book. The sun was setting. The courthouse stood behind them. The library waited ahead. This is love, Rachel thought. A child studying to protect his mother, a mother working to provide. Ordinary people doing extraordinary things. They reached the library. Mr. Patterson looked up. He smiled. I heard about the courthouse. Mitchell grinned. How? The whole legal community is talking. I couldn't have done it without you. His eyes got misty. You did it yourself. Thank you for everything. Mr. Patterson put his hand on Mitchell's shoulder. Thank you for reminding me why this work matters. Rachel watched them, 2 people who found each other. Returning those law books? Mitchell laughed. Can I keep them longer? Of course. They talked about the case. Finally, Rachel said they needed to go. Mitchell? Yeah? Check out constitutional law next time. Mitchell's face lit up. Really? Really? They left smiling. The bus ride was quiet. Mitchell leaned against Rachel. You did good today? We did good, Mom. Together they'd won. The bus stopped. They walked the last block. The same building they'd almost lost. Now it was safe. Rachel unlocked the door. Everything looked the same but felt different. They were different. Mitchell dropped his backpack. I'm tired. Go to bed. It's 7. You've earned it. He smiled and left. Rachel stood in the kitchen. This apartment was theirs. Nobody was taking it away. She pulled out her phone. Jennifer Martinez wanted Mitchell as peer educator. Rachel typed, We're interested. Thank you. She walked to Mitchell's room, knocked. Come in. He was in pajamas, the law textbook beside him. You don't have to study. Just looking at the cases we cited. Why? I want to remember this day. Rachel pulled him close. She kissed his forehead. Sleep. Love you, Mom. Love you too. She turned off the light, made tea, sat at the table. Her extraordinary son, who'd spent 3 years preparing, who'd stood in court and cited law, who'd saved them both. She sipped tea, let tears come, happy tears, grateful tears. For the first time in 3 years, Rachel felt safe. For the first time, she felt hope. Tomorrow, they'd rebuild. Tomorrow, they'd plan Mitchell's future. But tonight, they would rest. Winners, free. Rachel finished her tea, turned off lights, walked to her bedroom, and for the first time in 3 years, she slept without fear. Mitchell had given her peace. The courtroom victory was over. The battle was won. The real victory was this: a mother and son who faced impossible odds and refused to give up, who proved that preparation beats privilege, that knowledge beats power, that love beats everything. In their small apartment, Rachel and Mitchell slept, not as victims, not as underdogs, but as winners, as proof the system could work, as proof justice was possible, as proof one person could change everything, even a 9-year-old with a library card. Tomorrow would bring new challenges, the weekend program, the return deposit, rebuilding their lives. But tonight, they rested, safe, secure, home, together. The apartment was quiet now. No more crying at night, no more fear of eviction, no more wondering if they'd survive. Rachel lay in bed, thought about the day. The judge's face when Mitchell cited cases, the attorney's confusion, the gallery's applause, the impossible made possible. She thought about Mitchell. 6 years old when his father left, 7 when he started seriously studying, 9 when he saved them both, her baby, her genius, her hero. She thought about tomorrow, The security deposit would come, $1,800, enough to breathe, enough to save, enough to plan. Mitchell would join the weekend program, learn more, teach others, continue this incredible journey, and she would finally work one job instead of two. Be present, be there, be mom, not just exhausted, not just surviving, actually living. Rachel closed her eyes. Let sleep come. For the first time in 3 years, it came easily. No anxiety, no nightmares, just peace. Deep, beautiful peace. In the next room, Mitchell slept too. His law textbook on the nightstand. Always prepared, always learning. But now learning for joy. Not for survival. The worst was over. The battle was won. Tomorrow would be the first day of their new life. A life where they were safe, where they were secure, where they were finally, completely free. The Douglas family had faced the system, and the system had blinked first. Justice had prevailed. Love had conquered. And in a small apartment in the city, a mother and son slept the sleep of champions. Because that's exactly what they were. Champions, heroes, winners, and nothing would ever take that away from them again. The night was quiet. The city hummed outside. But inside apartment 3B, there was only peace, only rest. Only the sound of two people breathing. Safe at last, home at last, free at last. Together, always together. And that was everything. 3 weeks later, Stephen Moore's attorney called on day 13. The security deposit would be delivered, $1,800, full amount plus interest. The check arrived the next morning. Rachel held it, stared at the numbers, then cried. Relief tears. We're safe, baby. Finally safe. The following Saturday, Mitchell attended his first session at the Youth Legal Education Program. Jennifer Martinez ran it at the state law school. 20 kids aged 10 to 17. Mitchell was youngest. Within an hour, he was teaching. A teenager asked about burden of proof. Mitchell explained perfectly, used Ramirez as example. Jennifer pulled Rachel aside. He's extraordinary. The way he explains things, I'd like him to co-lead sessions. Ask him. Mitchell said yes immediately. The program met every Saturday. 3 hours. Constitutional law, civil rights, tenant advocacy. Mitchell absorbed everything and taught what he learned. Other kids called him Professor. He blushed every time, but loved it. Rachel kept her promise. She quit the weekend retail job. One job, just nursing. Still hard, still exhausting, but manageable. She attended Mitchell's school conferences, made him breakfast, was actually present. For the first time in 3 years, she felt like a real mom. Mitchell thrived. His grades became exceptional. Teachers noticed the change, the confidence, the spark. He's different this semester, his teacher said. More engaged, more alive. Rachel knew why. The fear was gone. Judge Patricia Wilson made changes too. She initiated a court program. Law students volunteered as friends of the court for self-represented litigants, help organizing documents, understanding procedure, preparing for hearings. The program was named the Douglas Advocacy Initiative. Mitchell turned red. They named it after us? After you, Rachel corrected. After us, Mitchell insisted. We did it together. Wilson invited them back for a ceremony recognizing community legal advocates. They climbed those same steps. Inside, the courthouse felt different, less intimidating. Wilson presented them with a certificate, but more importantly, she pulled Rachel aside. Your son changed how I see my job. He reminded me that the law isn't about power. It's about making sure everyone gets a fair chance. Rachel's eyes filled. Thank you for listening to him. Thank you for raising him right. Mitchell wanted to frame the certificate. Rachel said no. The real reward isn't recognition. It's what we have now. Safety, peace, each other. Mitchell thought. You're right. But can we still hang it up? Rachel laughed. Yes. At home, life settled into a new rhythm. Weekday mornings, Rachel made breakfast. Mitchell did homework. Normal family routine. Saturday mornings, the legal program. Mitchell teaching other kids. Saturday afternoons, the library. Mr. Patterson always had new books ready. You're ready for advanced material now, Patterson said. Really? Really, you've outgrown the basics. Mitchell glowed. Sunday evenings, Rachel and Mitchell cooked dinner together. Her nursing textbooks on one counter, his law books on the other, both learning, both growing. One evening, Mrs. Anderson from 3B knocked. Tenant issue. Management raising rent beyond lease terms. I heard what Mitchell did. Could he look at my lease? Mitchell spent an hour reviewing. Wrote a clear letter citing rent control ordinances. Mrs. Anderson sent the letter. Management backed down. Word spread through the building. Other neighbors came. Questions about rights. Help understanding legal documents. Mitchell helped them all. Rachel watched with pride. "You know what I'm proudest of?" she asked one night. "What?" "Not that you're smart, that you're good, that you use what you know to help people." Mitchell hugged her. "I learned that from you, Mom." 6 months after the hearing, Rachel got promoted. Charge nurse, better pay, better hours, benefits. She came home and told Mitchell. He hugged her tight. "We made it, Mom. We really made it." And they had. From the edge of eviction to stability, from fear to peace, from survival to actually living. One night, tucking Mitchell into bed, Rachel asked, "Do you ever regret it? The 3 years studying instead of playing?" Mitchell thought carefully. "No, because I got to save you, and that's worth everything." Rachel kissed his forehead. "You saved us both. We saved each other." He smiled, sleepy. "That's what families do." She turned off the light, stood in the doorway watching him sleep. Her extraordinary son, her hero, her Mitchell. She thought about that day in court. The impossible made possible. The system that worked when someone cared enough to understand it. The justice that prevailed when preparation met courage. She thought about the journey, the fear, the struggle, the late nights, the exhaustion, all leading to this moment. Safety, stability, peace. She whispered into the darkness, "The law is for everyone, baby, even us." And finally, completely, she believed it. Mitchell slept peacefully. No more nightmares about losing their home. No more fear about his mother crying at night. Just dreams, good dreams, dreams about the future, about helping more people, about becoming a real lawyer someday, about using his gift to make the world more just. Rachel walked to her own bedroom, lay down in the darkness. For the first time in 3 years, she felt complete peace. No anxiety keeping her awake, no fear about tomorrow, just gratitude for her son, for their home, for their second chance. Outside, the city hummed with life. Thousands of people, thousands of stories. Some would face injustice tomorrow. Some would struggle against systems designed to crush them. But maybe, just maybe, they'd remember this story. The story of a 9-year-old who refused to give up, who spent 3 years preparing for one moment, who proved that knowledge was power, that preparation could beat privilege, that love could overcome anything.